someone will always rather deliver a verdict that is the verdict sought by the party they favour. Bias means essentially you're more likely to favour one party than the other. The fact that the evidence, put it this way, you can have a case where a biased individual acts against their biases because the evidence is so overwhelming. That doesn't mean they weren't biased. It doesn't mean that there isn't a higher threshold to overcome if the bias is against you. Bias simply means you favour one party over the other. I mean, that's, in our submission, fundamental. And that's why the acquittal of Mr. Williams, in circumstances where the evidence against Mr. Williams appears to have been particularly weak, dependent on Mr. Chow alone, doesn't necessarily mean that. Now, my learned friend, in terms of jury independence and the relevance of Mr. Williams' acquittal, initially cited Gregory. Gregory, in fact, was the one where it was the case where the European Court found no violation of Article 6 in light of directions. Gregory, though, was followed by Sander, which my learned friend, I think, this morning accepted was the case where one person had been acquitted. The approach of the majority of the European Court was to find, and you see this, I think it's 7956, paragraph 30, was to find a violation of Article 6 because a racist juror can't be expected to change their views in response to a direction. Now that is, we would submit, consistent with Putnam recognising that there comes a point, essentially, at which prejudicial views become so embedded that you can't change your mind. My learned friend pointed to the dissenting judgment in Sander, but that's a dissenting judgment. The majority approach in our submission is the correct one, as I say, reflecting Putnam, and that demonstrates that the real problem in relation to the second aspect of my learned friend's case, which is the impact on the other jurors, which is the judge simply didn't have the information to know whether or not this was poison that could realistically be discounted on the basis of a direction. My learned friend also said you can discount unconscious bias because of the strength of the evidence. The jurors will essentially have said that they didn't need to consider the corruption because the case was so strong. The fundamental problem we would submit with that, ignoring some practical problems I'll come to in a moment, is that what that is doing is inviting the court to speculate about the jury's thinking. It doesn't know how the jury approached the decision making. By definition, the jurors may not know what factors, every factor that influenced them. We are potentially talking here about unconscious bias, and that is obviously something that the jury won't necessarily be aware of. And it's particularly difficult for the court to understand effectively the impact of bias when it simply didn't sit through this long trial. My learned friend summarised the evidence, but just pick up a couple of points out of that, and a sort of fundamental point that's at the heart of this. He started by referring to Mr. Chow's evidence, but Mr. Chow's evidence was clearly rejected in part by the jury because Mr. Williams was acquitted. He then relied on the electronic exhibits, but there, as he accepts fairly, there were arguments about the integrity of those exhibits. That's a credibility issue. He finally says, the heart of the defence case was that various exhibits had been fabricated. That is a credibility issue. That's an issue that requires assessment of what the officers and others said in cross-examination. And it's very, we would submit it's impossible for this court, many years after the event, with transcripts but not much else essentially, to assess the extent to which the jury would inevitably have discounted, because of the strength of the evidence, prejudicial material. In any event, fundamentally, that explains why there is a right to trial by an independent jury, because it's for the jury to assess facts. What my learned friend's submissions do is potentially undermine that right, and that explains why all the authorities demonstrate essentially that the proviso doesn't apply. What my learned friend was seeking to do in my submission was seeking to apply the proviso, having accepted later in his submissions that the proviso can't apply to an unfair trial. Well, if it's a biased jury, you have an unfair trial. And that's entirely consistent with Serafin as well, because it clearly, if the jury was unlawful because it was biased or indeed didn't comply with the Jury Act, Serafin paragraph 49 in our submission makes it clear the verdict can't be upheld. In terms of directions, Bonnet-Taylor in our submission reflects the approach in Smith that directions must be apposite, clear and emphatic. The reference to Smith I gave in opening, it's 7671 paragraph 24. The direction in Bonnet-Taylor that was upheld at 629024 was a specific direction.
Sorry, 6290?
6290 paragraph 24.
Thank you.
And that's the context of what followed, which was the assumption that the jury would follow the direction. It's important to note, however, that paragraph 25, the statement that there is an assumption that the jury will follow a direction, was then followed by paragraph 26, which started with the word however, making it clear there was a degree of qualification, that emphasised the importance of the protocol, the need to investigate, because you can't, in one sense, rely on a direction until you're satisfied that the matter is capable of being cured. Here, the problem with the directions were, firstly, they were to a juror who'd already demonstrated they would not comply with the oath. Secondly, those directions were given in the context of what was, by our calculations, a 5-day summing up, where there had been repeated references to the need to comply with the oath. And that, in one sense, means this just looked like a repeat of those directions. And those directions had been given in the circumstances where it would have been clear to the jury that the judge was concerned that they might be influenced by the fame of at least one of the defendants. And so the focus of those directions was, be cautious, you'll read a lot about this trial, essentially, but you'll be, and so there was essentially another direction, didn't expressly reference fame, but it was in the context of a situation where the judge was clearly expressing concerns about the impact of fame. In any event, as I say, we would say you can't give a direction that in circumstances where there is a risk of unconscious bias. It's very difficult to direct the jury in a way that will overcome that, if it's sufficiently embedded at least.
Why are we assuming it's unconscious bias? If every member of the jury has been approached and offered a bribe to acquit the defendants, I would think it was a quite conscious bias.
Well,
the jury would think, but the law does not think that would be a relevant matter going to their guilt or innocence. But of course their job is to decide it in accordance with the evidence. Isn't the real problem here that it would be a temptation hard to resist to decide or to be influenced in the decision of the case by something other than the evidence presented to the court?
Well, to be clear, I'm not saying it wasn't conscious bias. What I'm dealing with, what I'm dealing with is, in one sense, my learned friend's submission, which is to say, you can trust the jury to comply with a direction that they should I mean, there is a problem with how detailed the direction was, but let's assume that the direction was sufficiently detailed. You can trust the jury to comply with a direction that they should disregard this factor. And there's no reason in practice why it couldn't have said, because the jury were all meant to be aware of the bribe. I'm aware some of you have been approached about a bribe. You should. Now, the prosecution submission is you can trust the jury to comply with that. Whether that's realistic as a matter of human nature may be open to question. But assuming that's right, you still have the problem that even if a juror says to themselves, I understand that this looks pretty bad, that there was a bribe offered to us, but I understand what the judge has said. I need to put that out of my mind. It is very difficult, and this is why I focused on the unconscious bias aspect. It's very difficult as a matter of human nature to actually stop yourself unconsciously being influenced by that, because that's the way unconscious bias works. And that's why it's because I'm in one sense focusing on a particular difficulty that in our submission simply can't be addressed by a direction. But I accept that in reality, conscious bias is a very real problem here. Yes, in terms of just a couple of final features. Firstly, the procedure adopted. All we would invite the court to look at is, because my learned friend relies on it very heavily, Braithwaite 7358, the importance, in particular the citation at para 52 of an earlier case called Ball, the importance of matters being properly recorded in open court, which is the problem with the use of the forewoman, for example. That is important because it allows essentially